Right, before I hand over to Stuart, welcome to our last training session of the year. Thank you for joining us. We are currently in the process of putting together our 2025 training programme and hope to have that with you in the next couple of weeks, I'd say. So please do keep an eye out for it. We've got lots of family sessions lined up for you. So hopefully there's something on there for you. The only other thing that we have in the diary for this year is our AGM that's taking place on the 19th of December online at 3:30. So if you are able to join us for that, please do. Lastly, I'll just mention a couple of housekeeping notes. The session is being recorded for your information, and you'll be sent a copy of that recording after the session with the slides. Additionally, if you wanted to ask a question throughout the session, you can pop that in the chat or the Q&A box, and Stuart will come to them as and when. He'll also invite questions at the end. If you'd like to speak, please raise your hand and we'll facilitate that for you. I think that's everything. So, just another little bit of housekeeping. We'll have a short break at around 12:45. But that's it for me. So thank you very much, Stuart. We look forward to the course.
Thanks, Helen, and welcome to this session on fact-finding hearings and the role of the qualified legal representative in private children proceedings. I'm Stuart Barlow. I've been working in the area of family law for over 40 years. I've conducted many private children cases and in fact undertake most of my own advocacy. So what I am going to be able to say today is a reflection of what I've learned over the years. I've provided a set of notes to run alongside this presentation, which I hope you'll find helpful. But I'm happy to take questions as we go along or indeed at the end. And maybe we can even discuss some of your own experiences if time permits. So it's a focus on private children today. And you may or may not know that private law proceedings is big in the family court. In fact, there were something like 50,271 new private law cases started during the year 2023 and 24. And according to the joint research by CAFCAS and Women's Aid, domestic abuse allegations were present in something like 62% of private law children proceedings. And that's enormous, isn't it? By anybody's account, we have a real issue, and that's something that will be able to address, at least in some way, the practicalities and the process during the time we are together. Now, of course, some cases move through the courts very smoothly and there are no particular issues, but some present some real challenging issues. And we find ourselves wondering what to do and how to handle these situations. Now, it could be that you are an advocate and appear in the courts on a regular basis. But on the other hand, you may not be an advocate, or you may not be a person who undertakes their own advocacy very often. And there is no doubt about it that there are enormous difficulties. And I think that fact-finding hearings fall into the category of challenge. And fact-finding hearings, of course, arise where there is an unresolved issue of domestic abuse that could impact on the contact that would take place between a child and a parent. If contact does take place, can arrangements be made to ensure that contact is safe and does take place, at least in some form? Now, when dealing with private law applications, and in particular child arrangement orders, the court will make a number of assumptions. And I've set those out in the slide in front of you. This is still the position even when one party makes an allegation of domestic abuse. Now, what are these assumptions? And we'll just go through them one by one. First, the court must make a decision that is in the best interest of that particular child. And that's, for many of us, is pretty self-evident. The second is the court has a duty to promote contact with the parents in accordance with the child's rights to family life under Article 8 of the European Convention on Human Rights. Now, that's becoming quite a debatable point, actually, and there has recently been some pressure put on governments to change that. But as of now, and I suspect for the foreseeable future, that will always be the case, a duty to promote contact. And of course, it's with both parents. The third assumption is that there is no presumption either way as to whether or not a child should have contact with a domestically abusive parent. The fourth is that the involvement of both parents in the life of the child will further the child's welfare. Again, for some people, that's a debatable point, but that is the law, and that's something that we are working with on a day-to-day basis. So, of course, those are the assumptions. But these presumptions or assumptions are just a starting point and will not apply if the evidence shows that any involvement by the parent will expose the child to a risk of harm. There isn't a presumption or indeed an assumption that if the domestic abuse is proved or admitted, there should be no contact. But the court does have to look carefully at what the level of risk is and how it could be managed, and what possible advantages and disadvantages of contact might be. So you'll see that the court needs to exercise a balancing act, taking into account all these assumptions. In doing so, the court has the help of Practice Direction 12J. The full title is Practice Direction 12J, Child Arrangements and Contact Orders, Domestic Abuse and Harm. And this sets out points the court should consider where abuse has happened. And these are set out below. First of all, the effect of domestic abuse on the child where the child is living. The effect of domestic abuse on the child in the relationship with the parents. Whether the abusive parent is using the process to continue a form of domestic abuse against the other parent. And that does happen from time to time. You probably come across cases where contact with the child is just a means by which, say, the father is wanting to keep a relationship going with the mother who doesn't want that to continue. Father is using it as a means of doing what he wants to do. The likely behavior of the abusive parent during contact. In other words, how is he going to behave? And sometimes mums will say to me, if he has contact, he's got a temper that he will sort of display in front of our daughter or son or children and so on. And the final point is the capacity of the parents to appreciate the effect of past domestic abuse and its impact on the child. Once again, are the parents reflecting on the way that they behaved in the past and how they will for the future? The court would look at each individual case and see what is appropriate. In each case, the court still has to decide what is in the child's best interest. And that will mean whether contact is safe. In some cases involving domestic abuse, the question for the court is, how can contact be made safe? In other cases, the question is whether contact can be made safe at all. When the family court has to make decisions about a child's welfare, the court needs to know or decide what has happened in the past. Where the court has first to make a decision on whether the alleged facts are or are not true. In that case, a fact-finding hearing should take place before the court makes an order regarding the child in question. Until the court has decided whether the allegations are true, it will work on the basis that they might be true and will put safe arrangements in place That may mean no contact or supervised contact. And that's all part of the management of contact. If the court decides that a fact-finding hearing is needed, it will be required to put measures in place to bring this about. A fact-finding hearing is a court hearing that considers the evidence surrounding allegations made by one party against the other. The court needs to make a decision as to whether alleged incident did or did not happen. Evidence is heard which will normally include parties being cross-examined. After having heard the evidence, the judge or the lay magistrates will decide on the matter. Most commonly, these allegations concern domestic abuse, but can relate to other aspects of behaviour. Domestic abuse can include neglect, emotional and physical harm, and violence. It is for the party making the allegations to prove that they are true. The judge or the lay magistrates will consider, on the balance of probabilities, whether it is more likely than not that the allegations are true. In preparation for a fact-finding hearing, the party making the allegations will be directed to serve a list of allegations in the form of a Scott schedule. Each incident should be numbered and set out in date order, stating the date of the incident and details of what happened and where, details of any witnesses to the incident, and the involvement of the police and medical services. The person against whom the allegations are made will then be directed to respond to the allegations. The person accused should respond to each allegation in turn, setting out their account of the incident or stating that the allegation is denied. Both parties will also be asked to make a written statement, what I describe as a narrative statement, setting out their evidence. Witnesses can also make a statement and give evidence with the court's permission. And of course, courts are very keen to see the statement signed by the parties. So I quite often find that with litigants in person in particular, they don't put the statement of truth at the end, nor do they sign them. So there tends to be perhaps a little bit of discussion about how they're going to make sure that the parties sign the appropriate document. For them, it's a witness statement. For us, it may not be seen as a witness statement, but that's what it's supposed to involve. Now, how does the court decide which cases need a fact-finding hearing? When a private children case comes before the court, the application triggers a process requiring CAFCAS to carry out basic safeguarding checks. These reveal whether the family are known to the police or social services, or if the parents have any relevant convictions or pending prosecutions. CAFCAS will also attempt to speak to each parent on the telephone before the court hearing, that's the first court hearing, to check whether they believe that there are any safety issues. If a parent thinks that there are safety issues, they should raise these with CAFCAS during those discussions. Now, it's always been my practice when a mum, for example, raises concerns over the safety, that I emphasize that they raise those with CAFCAS at the time they ring, because if they don't, they could be missed. In practice, I find they're usually covered anyway, but it's worth reminding clients about that. Now, CAFCAS will then write a safeguarding letter setting out details of their inquiries and file this with the court and provide the parties with a copy. Again, it's worth just thinking about that. Sometimes you'll get to court and there isn't a safeguarding letter, in which case the case is likely to be adjourned. But of course, the court can't make a final order without a safeguarding letter anyway. But certainly in the area that I practice in Derby and Nottingham, safeguarding letters are usually filed promptly, and I hope that's the case with you. Now, in that safeguarding letters, CAFCAS may recommend that a fact-finding hearing is necessary before the application is fully considered by the court. My own reading of many of these safeguarding letters is that they'll often say the court may want to consider, but sometimes they go perhaps a little bit further by saying that they can't make any recommendation about the future of the case until a fact-finding hearing is necessary. What are the reasons for a fact-finding hearing? The decision about whether to hold a fact-finding hearing is for the court, not for CAFCAS or the parties. So even if you get to court and you arrive at a conclusion that a fact-finding hearing isn't necessary, you may find that the court overruled the decision of the parties. Remember, it's for the court to decide, and I sometimes warn my clients that if you arrived at an agreement that a fact-finding hearing is not necessary, the court could overrule that, and it's worth bearing that in mind. At the first hearing, what we call FEDRA, the full title is First Hearing and Dispute Resolution Appointment, the court has to consider Practice Direction 12J, which informs the court how it should approach cases involving allegations of domestic abuse. The thrust of Practice Direction 12J is that if disputed allegations would be potentially relevant, and it's important to emphasize that, to the final decision of the court should determine the dispute by deciding whether the allegations are true or not. The decision about whether or not to hold a fact-finding hearing should be taken early in the proceedings. So again, hopefully it's been raised in the safeguarding letter, but if not, it may have to be raised by you or your opponent at the FEDRA hearing, because the earlier, the better. The practice direction sets out a procedural framework to be followed. It's worth just reading that particular practice direction from time to time, just to remind yourself, and indeed I do that. I sit down over a cup of coffee and just remind myself. We tend to think that we know the contents, but actually we sometimes forget maybe the force of certain recommendations in the practice direction. Now, it sets out factors to be taken into account when determining whether to make a child arrangements order where domestic abuse has occurred. When deciding the issue of child arrangements, the court should ensure that any order for contact will not expose the child to an unmanageable risk of harm. The court is required in its judgment or reasons always to make clear how its findings on the issue of domestic abuse have influenced its decision on the issue of arrangements for the child. Now, sometimes you'll get to a FEDRA, and of course the court decides that a fact-finding hearing is necessary and puts a stop to contact, or indeed just refuses to make any order at all. And that can be frustrating for the client, because maybe a father has been waiting several months before they get to court. But of course, the courts will always take a cautious view, and it will not expose the child, or indeed a risk of exposure, in making an order. And so it's worth reminding our client the fact that if it is raised, then it's a question of trying to resolve, at least in the early stages, what sort of contact is going to take place. It may be restricted just to indirect contact, or maybe supervised contact, all of which the client will not be happy with. But nevertheless, it's something that we have to manage the client's expectations about. Now, Practice Direction 12J can be downloaded in full, free of charge on the internet. And as I've already said, it's worth looking at that, and I'd recommend that you do that. If a party has been directed to serve or respond to a Scott schedule, a template form can be used. And this is particularly the case if you've got a litigant in person, and we'll be looking at litigants in person later in our presentation. So you don't need to start from scratch. If you're not sure about a Scott schedule, how to draft it, there is material available. Now, I've already set out details of what the Scott schedule contains and its style, but I would make particular mention of the role of the judge or the lay magistrates. They will hear evidence and decide whether they find each allegation to be true. If the judge finds that an allegation is true, he or she will state that the allegation is found. If the judge decides that the allegation is not true, the judge will state that the allegation is not found. If the judge cannot decide whether the allegation is true or not, the judge may state that the allegation cannot be determined either way. Each party must prepare a witness statement in advance of the hearing. So we have a Scott schedule, and to back it up certainly in more detail will be the witness statement. Usually the person making the allegations goes first. Each allegation or incident will be dealt with by the parties in their statement. So you have the allegation made in the statement. Of course, whoever it is, often the father, will respond to each one individually. Now, sometimes the court will place a limit on the number of allegations that should be included. I've often found that litigants in person will draft a whole raft of allegations, maybe 30 or 40 allegations, and clearly the court is not going to be able to deal with those. So the first part of the hearing, in my experience of fact-finding hearing, is to decide what allegations are the most serious and prune them down, probably to maybe just 5 or 6, maybe even less, depending on the judge. It depends on the content. So, of course, if the court simply say, I'm not going to deal with all those allegations, so I'm going to place a limit on the number of allegations, then, of course, you need to go through that pruning exercise and decide that with your client, or the court may have to do that with a litigant in person. This is, of course, to ensure that the case is manageable and the fact-finding hearing is focused on the most relevant issues. It's not uncommon for the victim to set out this long list, so it's just worth bearing that in mind when you have a fact-finding hearing, that a little time looking through the Scott schedule, and maybe if it is beyond what I describe as 5 or 6, then you've got to see, certainly from your client's point of view, what the most relevant is and most important, and probably the most serious, really. What happens at the fact-finding hearing itself? The person making the allegations of abuse, and indeed any witnesses, will give evidence first. The accusing party will confirm or indeed correct their witness statements and may then be asked questions by the other party. Sometimes the judge will ask some questions. And not always the case, but certainly in most of the cases I've done on fact-finding here, the person who's making the allegations gives evidence first. And if you on the other side, you need to be fully prepared for what they're going to say. But as you probably know, if you're an advocate, what will happen is that if it's a properly drawn statement, they'll be asked to confirm that that's their signature, the contents are true, and the court are not likely to have any further evidence in chief. If, of course, there are further information, saying that there are more allegations, then, of course, that may lead to a delay or indeed an adjournment. But generally speaking, it runs smoothly according to the narrative statement. Now, the same process takes place for the person who is accused of abuse and any witnesses he or she is brought to court. So you have examination in chief for, say, mum. She's cross-examined by you or one of your colleagues, If there are any witnesses, you call the witnesses. And if there is, of course, the other party will then give evidence, again, go through the same process, examination and chief cross-examination. And then once evidence has actually been called, cross-examination has taken place for both the parties and the witnesses, then both parties will then be able to make submissions to the judge. And the judge will announce the decision and give reasons. You probably appreciate that there is a significant difference between judges and magistrates when it comes to these findings. Quite often the judge is able to make decisions fairly quickly. Magistrates may go into their retirement room and take quite some time to come to a conclusion. But of course, at the end of the day, the process is exactly the same. Now, the process and the actual hearing itself may change according to whether the parties are represented or not. But whatever the process is, it's important that both sides have an opportunity of presenting their case well, and the court then come to a conclusion on whether the allegations are true or not. We haven't, of course, got anywhere near any formal order being made at that stage. I'm going to say quite a lot more about this when it comes to qualified legal representatives. But moving on now to the question of finding of fact hearing, I now want to look at the whole issue of finding of fact hearings. Now, finding of fact hearings have recently been subject of some scrutiny, both by the Ministry of Justice and the courts themselves. In fact, have recently probably goes over several years now. Whilst I've said what I've said already currently stands as good authority, there is the possibility that changes could take place at some time in the future. But for the moment, I can say to you that all the authorities that we've been looking at still stand as good law, and I think it's going to be some time before there are any changes. I think what it calls for is some a change of certainly procedure, and as you know, very often with changes of procedures and laws, it does take some time. Now, following the cases in the Court of Appeal of Re-Chen and others, that was in 2021, the court raised a number of important points. It was accepted that Practice Direction 12J remains fit for purpose in providing the courts with a structure on how to approach private law cases when allegations of abuse are made. Now, I pause there for a moment because we have a judge in the East Midlands who I know well, and when she comes to dealing with fact-finding hearings, she often pauses by saying that she is no great fan of Scott schedules. But of course, she's bound by Practice Direction 12J, and she may want to avoid them sometimes, but at the end of the day, Practice Direction 12J is fit for purpose, and therefore whatever's contained in that practice direction is important to follow. The second point that HN said was specific directions was given by the court in relation to whether there should be a finding of fact hearing at all and the use of Scott schedules. Now, that particular circuit judge that I've just referred to is to some extent following the line of the Court of Appeal, because the court heard submissions from the parties as to the usefulness of Scott schedules, and the court's focusing on a list of specific incidents, each tied by time and date, rather than on whether there has been a pattern of behaviour. The parties had also been required to limit the number of allegations to be tried, going back to the point that I made earlier about the court sometimes pruning down the number. And the court concluded that, and I'm quoting, serious thought is now needed to develop a different way of summarising and organising the matters that are to be tried at a fact-finding hearing. Quite how a move away from the use of Scott schedules is to be achieved, and what form any replacement pleading might take, does, however, raise difficult questions. The process before this court has undoubtedly confirmed the need to move away from using Scott schedules. This court is plainly not an appropriate vehicle to do more than describe the options suggested by the parties. It will be for others to develop those suggestions into new guidance or rule changes. So, of course, simply repeating myself is the fact that it's not likely to happen because changes both in guidance and rules need to be addressed. The next point that the Court of Appeal dealt with in HN was the court also considered the approach in dealing with controlling and coercive behaviour. The court said that until such times as there is new guidance or a change of rules, cases of domestic abuse will continue to come before the court, and with an increased focus on controlling and coercive behaviour. The court determined that where a party properly raises the issue of whether there has been a pattern of coercive and or controlling behaviour, it is the responsibility of the individual judge or bench of magistrates in each case to set a proportionate timetable and to maintain control of the court process where it has been determined that a fact-finding hearing is necessary. It is, however, our expectation that in cases where an alleged pattern of coercive and or controlling behaviour falls for determination, the court has made that issue its primary focus. The need to determine a range of subsidiary date-specific factual allegations will cease to be necessary. Now, in practice, I don't find it a particular problem because if there has been some kind of behaviour over a period of time, when I draft the Scott schedule, I quite often say these are the allegations over a period of time. And provided that you've got sufficient evidence to be able to support that, if you like, general statement, I don't think the courts have any particular difficulties in addressing it. The next point was that the Court of Appeal also made it clear that criminal law concepts should not be imported to the family court. Now, the court referred to the case of Re R, which went back to 2018, where it was held that as a matter of principle, it was fundamentally wrong for the family court to be drawn into an analysis of factual evidence in proceedings relating to the welfare of the child based upon criminal law principles and concepts. I'm not going to dwell on that particular case, but it's just worth bearing in mind that, of course, standards are different. It's on the balance of probabilities, whereas, of course, in criminal cases, it's beyond reasonable doubt. But sometimes we can look at it, if you like, with a criminal lawyer's eye, and we need to be just conscious of the fact that criminal law really has no bearing on family courts. Once again, it should be stressed that this guidance given by the Court of Appeal in those cases has no formal legal authority at present. But it is likely that changes will be made on these issues in due course. You may even see it applied in some courts already under the principle of judicial discretion. It's just worth thinking that out. When HN first came out, I remember having an opponent who started to argue on certain principles under HN, and the district judge made it clear to the other side that it was simply guidance and it didn't change anything at all. And they were just comments by the Court of Appeal, which of course is absolutely right. And so if you come across somebody who's arguing the HM, that there should be some changes, then you need to bear in mind, of course, that it is guidance and the court need to take that into account. But sometimes district judges and even circuit judges may have a particular agenda which they want to use, and we need to be just aware of that. So I put up the fact of HN. I'll come on to K and K in a moment, but more recently is the case of AA and BB, which was in 2021, involving a private children proceedings case. I've set these out in the notes, but this case is one of the first reported cases to consider the implications of re-HN. In that case, the appeal was against a case management decision to exclude evidence from a fact-finding hearing. The mother relied on the dicta of the Court of Appeal in re-HN regarding the limitations of Scott schedules and the fact that the court focused on particular allegations rather than just looking at patterns of overall behaviour. Even more recently, that's in 2022, the Court of Appeal has heard the case of K&K. And this is what it states. This judgment is intended to provide general guidance on the proper approach to fact-finding hearings in private family proceedings following this court's decision and re-HN. Now, I'd encourage you once again to download the full decision on the internet. But, and of course, it does reflect quite an important principle. But my own summary of the principles in K&K are these. First of all, the nature of the allegations and the extent to which those allegations are likely to be relevant to the making of the child arrangements order. So you may come to the conclusion the allegations are there and they may or may not be true, but are they relevant to the final decision that's going to be made? The second point is that the purpose of the fact-finding hearing is to allow assessment of the risk to the child and the impact of any abuse on the child. I did a case only last week where I was cross-examining. I was a QLR as it happened, but I was cross-examining mum, and I went through the allegations, and really they focused on her, and it seemed to have no real bearing on whether there was a risk to the child or not. And she just simply wanted the court to hear that the father had abused her, and that the court needed to take that into account. But of course, the whole purpose of the hearing is to assess the risk to the child. Now, of course, it can, if there's abuse on the mother as an ongoing basis, if it impacts on the child, that's another matter. But if they're historic allegations, and of course it doesn't lead the court to make a final decision and help the court, then of course the court can't take it into account. The next point is whether the fact-finding hearing is necessary or whether other evidence suffices. And sometimes the court can say, well, we know enough about the allegations. Some of them clearly are true. Some of them are in dispute. But we don't really need to have a separate, if you like, a hearing within a hearing, a trial within a trial, to deal with this particular matter. We have enough information to be able to move forward. And whether the fact-finding hearing is proportionate. How we define proportionate is a matter, of course, for you and the courts to decide. But it's important to just bear in mind that just because there's allegations of abuse, it doesn't necessarily mean there's going to be a fact-finding hearing. Now, in the case of K&K, and I think this is important to just hear, the court expressed concern that a perception had formed that re-HN created a requirement that in every case in which allegations of domestic abuse are made, the court should conduct a fact-finding hearing exercise with a detailed analysis of each specific allegation. The Court of Appeal reiterated that the court's duty is limited to determining factual disputes that are likely to be relevant to deciding how to make a child arrangements order. So does it lead the court to be able to make a proper decision, and the decision has to be based on what the evidence is? The emphasis now placed by the Court of Appeal on relevance and the effect of disputed facts were expressed simply in paragraph 45 of K&K, which says this: without in any way resiling from what was said in Re HN about the pernicious nature of domestic abuse, fact-finding is only needed if the alleged dispute is likely to be relevant to what the court is being asked to decide relating to the children's welfare. I think this case sends a signal to family courts to be more careful when deciding on the need to have a fact-finding hearing. Maybe to be more discerning, in other words. Now, the second issue that came out of K&K is the question of mediation. As you know, it's a burning subject and has been for many years, but particularly so since the change of rules, family procedure rules. But in some respects, it could be seen as an unrelated matter within the context of K&K. But I think it's particularly pertinent now we are looking at the question of domestic abuse. Now, I don't know whether your experience has been the same as mine, but I've tended to assume in past years, well, if there's domestic abuse, then mediation really is just not a matter of discussion. But in fact, K&K was saying something quite different. And it said this, that the court said that it was unfortunate that the parties in this case did not take advantage of mediation. Now, my take on this is that the court used the case to make the point to parties and others whilst it had the chance. Ironically, it seems that K&K could have been resolved had mediation been attempted, despite the allegations of abuse. Now, I've provided a number of other reported cases in my notes, which I hope you'll find helpful. But let me summarise the position before we have just a short break for a coffee and so on. Let me just summarise what area we've covered and where it's brought us. In an application for, say, a child arrangement order, that's your C100, CAFCAS will carry out their checks and report to the court. In that report, there may be issues of domestic abuse raised. The court will then decide if a fact-finding hearing is necessary. If the answer is yes, directions will be made for a Scott schedule, response and statements by both parties. A hearing will then take place when both parties will give evidence and be cross-examined. The court will decide on whether the facts are true or not and give reasons for that decision. A further hearing on the application itself will then take place. Probably directions will be made for, say, a Section 7 report to be filed. And then the court will then decide on the issue as a whole. So quite often what happens after a fact-finding hearing is the decisions is made and then goes off to another date, maybe for a Section 7 report. And that, of course, will arise particularly if you have a situation where a CAFCAS officer has said, we can't make a decision until we know the result of the fact-finding hearing. That will inevitably lead to a report. But it could be that even if there is a Section 7 report, it could need to be updated in the light of the court's decision. Just a few practical issues, if I may. It's more common to see fact-finding raised in safeguarding letters nowadays. And indeed, it's more common to see fact-finding hearings generally. Sometimes CAFCAS will make a clear recommendation, but often they will ask the court to consider a fact-finding hearing. I suspect what they're bearing in mind is the fact that judges have to make the decision, not them. But they will put it in such a way maybe they appear to be sitting on the fence, but actually they're giving a fairly strong steer as to the way forward. In either case, you'll need to prepare to argue the point on whether a separate fact-finding hearing is really necessary. And so once the question of allegations are made, then the court, of course, will need to make a decision, and the judge will want to hear from you. They won't just simply make a decision on the light of that. The court may say, well, is it a balancing act, bearing in mind REHN and K&K? Where do you stand on this? What are your arguments? Now, courts have historically taken a cautious approach in directing a fact-finding hearing is necessary. And indeed, CAFCAS are the same. One judge asked counsel in a case very recently, is it true that CAFCAS are risk averse? And I think the counsel returned and said they are. And so, of course, no one wants to get it wrong. No one wants to make an order when there's been allegations. But of course, that's something that the court will need to grapple with and take that, if you like, discerning approach. Don't assume that as CAFCAS have raised the point, it will inevitably lead to a fact-finding hearing. Remember K&K. If both sides are legally represented, of course, you can discuss the matter with the other side. But what did your client think? Think of the consequences of a fact-finding hearing. More work on a Scotch schedule and statements, which they've got to pay for. Delay, especially with the courts being so busy and difficulty in listing a case. And of course, it could be some time before the fact-finding hearing is necessary and heard. And also, it could be some time before a final order's been made. And in today's world, with family courts being so busy, you could be talking about 6-12 months, which of course is in nobody's interest, particularly the child. And maybe the final question we have to ask ourselves in these things is, will it take the case any further? Even if the judge arrives at a decision that domestic abuse has taken place, will it help the court in deciding on whether contact, for example, should take place? So that's where we are. Going to have a just pause for 5 minutes or so, and then I'll see you in 5 minutes or so. Thanks very much. Welcome back, everybody. So, in terms of, let's get the right slide. I'd like to now look at the subject of litigants in person in fact-finding hearings, and it could be something that you've had some experience about, and litigants in person are arising not just in private children cases, but also in financial matters, not so much in public law cases, although they do from time to time, but certainly in domestic abuse case and non-molestation orders, litigants in person arise all the time. But it's interesting to note that if you're dealing with private children cases, often your opponent is not legally represented. In fact, the statistics, which I think by and large are in short supply, but the latest figure that I've seen is that only 25% of private children cases have both parties legally represented, which is really quite serious, isn't it? Now, this means that around 75% of children cases involves a litigant in person. Now, of course, that's a fairly rough estimate, but I have to say that when I'm dealing with private children cases on a regular basis, I always think it's a bit of a bonus if the other side is legally represented. And that does, of course, have a direct bearing on how cases are dealt with. Now, in my experience, most district judges are experienced in handling litigants in person, and they do ensure that there is fair play. And indeed, they go out of their way to make sure that both parties are heard well and will take up questions for cross-examination and ask them on behalf of the litigant in person. And we'll be looking at that under the adding of QLR in a moment. But let's just look at the issue of litigants in person, because judges have their own guidance. Now, according to the most recent version of the Equal Treatment Benchbook, that's the, if you like, the encyclopedia for judges, at any court hearing, a judge should aim to ensure that litigants in person understand what is going on and what is expected of them at all stages of the proceedings. And that's before, during, and after any attendances at a hearing. The key, for the judge anyway, is to maintain a balance between assisting and understanding what the litigant in person requires, while protecting their represented opponent, of course, have got legal representation, against the problems that can be caused by the litigant in person's lack of legal and procedural knowledge. The judge treads a fine line between making sure a hearing is productive and worthwhile, whilst at the same time ensuring that the unrepresented party has a fair and proper hearing. A litigant in person is expected to comply with all the court rules and procedures, as confirmed in the case of Barton and Ryan Hassel as far back as 2008. But there will often be a need by the judge, particularly, to take a more flexible approach in family cases, as stated by Lord Justice Mumby in the case of Re C in 2012. A fairly recent case in the Court of Appeal revealed that a judge can go too far in attempting to direct the case in a particular direction in order to assist the court process. In the case of Re Inkster, which is 2020, so it's not that long ago, the Court of Appeal was satisfied that the circuit judge's uninvited interventions and the consequent impact upon the unrepresented appellant, remember unrepresented, created inappropriate pressure on the appellant's freedom of choice. The appellant had pleaded guilty to 3 counts of breach of non-molestation order and was sentenced to a conditional discharge for 6 months. The primary ground in the appeal was the appellant's decision to change his plea and whether it was voluntary or not. The pressure placed on the appellant by the judge resulted in the appellant feeling that he had no choice but to plead guilty. The appellant was unrepresented at the hearing in the lower court and argued that he was an unfamiliar environment. At the appeal, it was suggested by the Crown that the appellant was an intelligent and articulate man who chose not to be represented. He understood the process and engaged with it. He understood the law and was capable of representing himself. The Court of Appeal rejected these arguments as the trial judge had effectively advised the appellant as to a particular course of action. The moral of the story is that a judge must exercise his or her role with great care when dealing with a case involving a litigant in person. The judge appears to have attempted to assist the case by expressing his view in such terms that the unrepresented party felt that he had no choice but to follow such advice. This was clearly exceeding his role, and such intervention proved to be incorrect in law. Another aspect of the case was the involvement of counsel for the Crown, and that, of course, at the first hearing. He volunteered to speak to the appellant during the luncheon break and act as a wise ear, and we can see ourselves in this situation ourselves. Counsel appears to have given advice to the appellant, which may have led the appellant to believe he should follow the judge's indications. He seems to have done so with every good intention. And of course, the intention was to assist the court as well as the appellant. The Court of Appeal took the view that by meeting with the appellant, counsel may have made the situation worse. Now, whilst that case was a criminal case, the principles in handling a case involving a litigant in person still stand generally. So you can see this in a perhaps more informal setting where the judge is trying to help the case by assisting both parties, particularly a litigant in person. They have no idea of the process, and the court sort of implies to them that they should take a particular direction. But judges are in a difficult position because, on the one hand, they want to make the whole thing work, get a hearing effective. On the other hand, they can't steer it in a particular direction according to their own views. Now, another case that came before the Court of Appeal was the case of Rhea in 2022, so we're not going back that long. The court heard that the deputy master questioned the respondent on a number of topics and raised the appellants. Now, of course, those particular topics were very much dear to the heart of the appellant. Now, when they indicated they wished to raise some questions themselves, so clearly the judge had asked some questions, when they want to get stuck in and ask questions, the judge effectively refused. And he intervened after 4 questions to stop those he considered to be irrelevant. The fundamental importance of the right of the litigant to cross-examine an opponent's witnesses in an adversarial system has been emphasised, said the judge, in many cases, and is the foundation for what has been termed the core principle that the judge, and this is worth thinking about, and I think it's a great quote really, the judge should remain above the fray and neutral during the elicitation of the evidence by the parties. So if you're involved in a case and the judge is steering it in a particular way, we need to be conscious of the fact that judges do have to have that neutrality. The other thing that I find sometimes frustrating is that judges don't say anything. So you've got no idea of whether what the judge is thinking about. And perhaps the judge could say certain things to help. But you have to bear in mind that the judge does have that very delicate position to hold. And Lord Justice Snowden in the appeal said that there was a world of difference between a judge taking steps to assist a litigant in person to put their case to a witness for comment, and an effective cross-examination designed to extract admissions. Now, taking all this into account, we see the fact-finding hearings can be a challenge, procedurally and practically. And there are times when we can all be caught up with the difficulties themselves. Now, that brings us on to qualified legal representative, because I think to a certain extent, and certainly to some extent, that problem for the judge is relieved. And why do I say that? Well, for some time, the judiciary has called for the provision of an advocate to ask questions of a vulnerable witness on behalf of a litigant in person. Now, I've always been very conscious of a litigant in person, not knowing the system, not knowing what to say and what to do and when to say it. And I've been involved, maybe representing a mum in a case where the litigant in person is frankly clueless. And sometimes they don't take steps to protect their position. And I've often wanted to jump in and say, this is what you need to do. But of course, we can't do that. Now, the introduction of a power for courts to appoint a qualified legal representative, known as a QLR, and I'll use that expression throughout now, to undertake cross-examination is set out in the Domestic Abuse Act 2021. Now, I am a qualified legal representative, so I get called in by the court to undertake a test, which I'll explain in a moment. But for me, I think it's really exercised that balance between with a litigant in person who is clueless, but the most important part of the case is cross-examination. Now, as a result of the Domestic Abuse Act, the prohibition of cross-examination of litigants in person has arisen. So let's just sort of picture this happening. You've got mum who's, say it's in a children's case, mum is legally represented, dad is a litigant in person, is not legally represented, and she alleges domestic abuse, sometimes quite serious abuse. In practical terms, because he has the right to hear his case, he would normally cross-examine his ex-partner. And that can be in itself an horrendous experience for her. And so the government have given rise to the appointment of this qualified legal representative, the QLR, to be brought in to undertake the task of cross-examination. So we don't have a confrontation between the litigant in person, the alleged abuser, and the witness in the witness box, mum, the abused. So the coming into force of Section 65 of the Domestic Abuse, I'll just move my slide, was on the 21st of July 2022, and that saw the introduction of the prohibition of cross-examination in person by parties alleged to either victims or perpetrators of domestic abuse. So in practice, what happens is this, that the court brings somebody in, and the idea is that first of all, the litigant in person is prohibited from cross-examining the victim. So they can't simply do it. They're not allowed to do it. But the courts can't simply leave it like that. In fairness to the man concerned, it's nearly always the man, but the man concerned, he's got to at least have somebody to ask questions on his behalf, which is where the QLR comes in. Now, let me just set out a summary of the changes that brought about. Now, it's just over 2 years since it all came into being. The interesting thing is that it only related to applications after July 2022. So it took a little time for these cases to come through. you may be interested to know that I was appointed QLR in 2 cases where I shouldn't have been appointed. It was still before the court, but when I looked at the date of the application, it was prior to the 21st of July 2022. And I had to point out to the court that I couldn't actually accept the role. And so, of course, that's the way it goes sometimes. We are working through the system now, that most cases, certainly that I deal with, have been applications following July 2022. And it's just worth thinking about that. So under the new Act, that's the Part 4B of the Matrimonial and Proceedings Act 1984, there can be prohibition on cross-examination in 4 circumstances. First of all, where a party has been convicted, cautioned or charged with a specified offence. So that's the easy bit really. Where a party is subject to an on-notice protective injunction, that's fairly straightforward. Where there is a specified evidence of domestic abuse and a catch-all category, which tend to be much more general, and the court has the power to prohibit a party from cross-examining a witness in person if the quality condition of the significant distress condition are met and it is not contrary to the interests of justice to give the direction. Most of the cases that I've been involved in as a QLR have been in that, if you like, that catch-all situation. There's no criminal conviction, there's no injunction in force, but it's quite clear from the allegations that the father in that case should be prohibited. So where any of these conditions are met, the court will consider whether there are any alternative means for the witness to be cross-examined. Remember, the judge holds the key to this because, of course, he will need to help the litigant in person. So is there any alternative? Is there any other evidence that can be brought to avoid a qualified legal representative being involved? In cases where the court considers there is any alternative, it must invite the parties who would undertake cross-examination to arrange a legal representative. So they look at it and they say, first of all, we need to prohibit. Secondly, can he get legal representation? When there's a litigant in person, it's not likely to bring somebody in, although I have known cases where they have done. They've realised the situation. But if they don't find legal representation or they choose not to find it, then the court will, in the interest of justice, appoint a qualified legal representative. And the legal representative is somebody who is deemed to be fairly experienced in private children cases and have undergone a training course, usually a day, of dealing with vulnerable witnesses. Now, as we've seen earlier, many private family cases involve one or both parties being unrepresented by a qualified lawyer. And we've also seen that up to, in fact, 70% are in that situation. Family courts now have struggled to cope. So therefore, they look at the qualified legal representative, the QLR. I want to just take you through how it works in practice. And it's quite interesting, really, because the court, first of all, will make clear to the prohibited party that the qualified legal representative is not their lawyer. Now, in practice, what happens is this, and I'll just get out a court order, that the court, first of all, prohibit. Secondly, the party's not got a lawyer. Therefore, they have to appoint a qualified legal representative, and they do it in this way, that they send an email, what I've described as a round robin email, to all the people on the list of qualified legal representatives in a particular court. And so there may be 30 or 40 of them in a big court. There may be only just a handful. Apparently, nationally, there's something like an average of 2 per court. So there will be courts where they're very low or hardly any, and others where there's an awful lot of them. So they will send an email to me and I respond. And if they the court appoint me as a QLR, they send me an order. And this is what this particular order says. It's in a private children case. Upon the court considering whether it's necessary in the interest of justice for the witness to be cross-examined by a qualified legal representative, and concluding that it is necessary to appoint such a qualified legal representative to conduct cross-examination, it is ordered that the court has appointed a qualified legal representative, a QLR, in the name of Stuart Barlow, give my email address, on behalf of the applicant, it names the applicant, for the finding of fact hearing listed on the 15th of May 2024 and 16th of May 2024 at 11 a.m. with a time estimate of 2 days at the Family Court in Derby before District Judge, and it names District Judge, as an attended hearing. The court is authorised to share the contact details of this particular person with the court-appointed legal representative. So that's the sort of order that I will receive, and I had one yesterday. I've usually indicated, obviously, beforehand, A, that I'm available to do the hearing, and B, there is no conflict of interest. So the court will make it clear what the position is, but what does he do? What is the role of the QLR? And that's where it becomes interesting, because people think a QLR is there to represent the litigant in person. And the answer to that is, that's not correct. They're not. They're simply there to cross-examine. But how does it work out in practice? Now, what I do is that I get that order and I make contact with the litigant in person. That's probably the minimum I would do. But I would normally speak to them, and I will get a copy of the bundle from the court as well. It may be out of date bundle, it may not be up to date, but it's something. And I read through the bundle and find out what the case is about. And then I speak to the litigant in person on the telephone. I don't meet with them. I make it clear that I'm not their lawyer and that I'm appointed by the court. And my job is simply to cross-examine. And it's usually the mum. It could be certain witnesses, but usually only the mum. And my communication with the litigant in person is going to be limited. Some litigants in person expect you to take over the job. The answer to that is you can't do that. And I'm simply there. Some QLRs are very strict. They don't make any communication with the parties. They don't even talk to them about their case, because when I start my cross-examination, I usually say to the so-called victim, my name is Stuart Barlow. I'm a court-appointed legal representative. I don't represent your ex-partner. Questions I'm going to be asking are my questions and not his, and you need to bear that in mind when dealing with the matter. Now, of course, you've laid all those things out to your litigant in person. We talk loosely about him being our client, but he's not our client. There is no solicitor-client relationship. I don't have to report to him. I don't actually, in full, have to ask him what questions he wants asking, because they're my questions. But I do. I usually work with him because I work, if you like, as a team. And almost by the time you get into court, you feel as if he is your client. But that's my personal approach. And I look at the bundle and I prepare cross-examination. And what actually happens is that during the hearing, it starts in the way that I described earlier, in that the victim usually gives evidence, gives examination in chief, and then the district judge or the magistrates will turn and say, okay, Mr. Barlow, it's up to you, and do those preliminary remarks, and then ask the questions. And at the end of cross-examination, I leave the courtroom. Sometimes things are slightly different, generally speaking. So the district judge will say, Mr. Barlow, you finished cross-examination. Would you like to be discharged? And I say, yes, I do. And I say goodbye to the litigant in person, and that is it. But it doesn't always work out quite like that, because, of course, by the time you've got to know each other, you feel, if you like, an affinity, a professional affinity towards the person concerned, and of course you want the best. So sometimes they contact me and tell me what the outcome is. Invariably, I need to know the outcome, but part of the order actually says what time I spent and the details of the district judge, the type of case, and so on, so that I can then claim my fees from the legal aid agency who pay for the fees of the QLR. So that's the way it goes. And because there's been an increase, there's been a shortage of QLRs. And that's why I made reference to the case of Re Z in 2024, which the President of the Family Division has been very involved with. But before I move on that, I want to just say that there is a statutory guidance set up by the Ministry of Justice on how a qualified legal representative, a QLR, will operate, what they do and do not do, what they have to do, and so on. And it's very similar to what I've already proposed and suggested, that it's a limited role and we don't have anything like a solicitor and client relationship. Some QLRs, I'm told, in parts of the country, barely speak to their litigant in person, and they're very strict about what they will and will not do. Some of us perhaps get a little bit more embroiled in advising them because, of course, my job is not to advise them, make it clear that that's not their job. But you do, because that's part of the job that I've been doing for so many years. But of course, the statutory guidance makes it clear. So there are very great limits. So even when we talk about our client, that's not the right expression. Last week I was in a case where there were two QLRs for each party, and the barrister representing the mum in that case said, "Oh, my client," and then he pulled himself up and he says, "Sorry, she isn't my client." So we need to remind not only ourselves, and sometimes judges ask us to get involved in things that outside our remit. In fact, both of us in that case that I've just referred to, we ended up by cross-examining the CAFCAS officer, but we agreed to do that. But that wasn't part of our role. But we felt that it was in the interest of A, the parties, and B, the court and the judge to be able to do that, just to clarify certain issues. So that's the role, that's the statutory guidance. It only obviously applies to those who are QLRs. But there is, and has been, an acute shortage of QLRs. In some parts of the country, one usher said to me, they're like gold dust. In fact, certainly in the courts in Derby and Nottingham where I operate, there isn't a shortage. And I can sometimes volunteer to take on a case only to find that I'm not appointed at all. In fact, that happens quite often. So that's a good thing for these Midlands. But in other parts of the country, QLRs are very uncommon. And that's what actually happened in the case of Re Z. And I'm going to bring our session to an end on this case. And Re Z, and I've given you details in the notes in some detail. But in short, the court tried to appoint a QLR, and it was clearly one where there was a prohibition. And if you can't get a QLR, the district judge, circuit judge, or the magistrates have to help the litigant in person. But in short, what actually happened is that they simply couldn't get a QLR, and there was a request to appoint somebody who just, there wasn't anybody available for some particular reason. And it went out many, many times, and the judge ended up by having to undertake the task. And that particular case really describes the situation. What do you do if you can't appoint a QLR? And what does the judge do in those circumstances? Now, I know that most judges are very keen for QLRs to be appointed because it means it takes the weight off them to ask the questions. And if you like, turn the clock back by them having to do justice to a case, which could be done better if a QLR is appointed. I remember on the case, one of the cases I referred to, where I pointed out to the judge I couldn't be appointed because it was the proceedings prior to the commencement of the Domestic Abuse Act. And he said, I don't have the power, Mr. Barlow, to appoint you. It's born in statute, of course. He said, I wish I could. And in fact, I suspect that judges around the country wish we could, but we can't. And so, of course, it meant that this particular judge couldn't have the assistance of a QLR. So that's the position. I think I brought it to an end, but I've just left a few moments if you want to ask any questions, either through the microphone or the chat box. That would be great. But in the meantime, thank you so much for joining me. I hope the session has been helpful, and that you'll be able to put some of the things I've talked about this morning, and just this morning and this afternoon, into practice. Thanks very much indeed.